So, did you talk to Miss Barrett? Okay. Do you want her brought down?
Yeah.
Okay.
Oh, yeah, excuse me.
Oh, I thought you wanted to talk to her. All right, and neither of you, Diane Moliterno has somebody in jail. So. Hi, this is Judge Anslone. I was wondering if I could get, all right, so Andrew Sprague, they waived, so I don't need them today. But I'm ready on Mark Regalado, Casey McKenzie, Troy Johnson, and Scott Rogers. And then when they're all done, I'll take Mr. Oglesby.
You said Scott Rogers as well.
Yeah, everybody, and then Marcus Oglesby last. Okay.
All right, we'll get them in for you, ma'am.
All right, thank you so much.
Yep. Bye.
Okay, so in the matter of Jerry, the people of the state of Michigan versus Jerry Lee Rellerford, is he here? No, file number 21-20509FH. This is the date and time set for a show cause for violation of probation. Mr. Rellerford sent a notice to appear. Mr. Rellerford has failed to appear. So I will issue a bench warrant for his arrest and will set bond in the amount of $1,008 cash.
Thank you, Judge.
Thank you.
That's all I had.
Do you need to talk to her or?
I've talked to her.
All right, you can come on up. Thanks, Miss Holly. This is in the matter of the people of the state of Michigan versus Samantha Jo Barrett. File number 24-21861FH. Did they fingerprint you over at the jail?
They have.
Okay, good. So I have John Glazier appearing on behalf of Miss Barrett, and I have Alexander Bandetto appearing on behalf of the people. This is the date and time set for pretrial. Mr. Glazier, how would you like to proceed?
Your Honor, my client's gonna plead, I don't know if it's on there yet or not, but it would be to an added count of possession of cocaine.
All right. And count one would be dismissed.
That's correct, Your Honor. And then we wanted to address bond if we could.
Okay. All right, so Ms. Barrett, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, can you state your full name for the record?
Samantha Jo Barrett.
All right, scoot up a little bit towards the microphone, and I'm going to need you to speak loudly for me, okay?
Samantha Jo Barrett.
All right, thank you. So Ms. Barrett, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to an added count 2 possession of cocaine, which carries a maximum penalty of up to 4 years in prison?
Yes, ma'am.
All right, are you satisfied with your attorney and the advice that he has given you?
Yes, ma'am.
Do you understand that the maximum penalty for this offense could be up to 4 years in prison?
Yes, ma'am.
All right, and neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Glazier?
That's correct. Your Honor.
Mr. Bandetto?
That's correct, John.
All right, is that correct as far as you're aware, Mr.
Yes.
Barrett? Okay, so if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
Are you currently on probation?
No, ma'am.
Okay. How do you wish to plead to the charge that on or about June 7th of 2024, the city of Adrian and the county of Lenawee, that you did commit the offense of possession of cocaine? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier.
No, Your Honor.
Mr. Banetto.
No, Your Honor.
Has your attorney promised you any particular sentence or estimate what your sentence will be?
No, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
All right, so Ms. Barrett, on June 7th of 2024, were you in the city of Adrian in the county of Lenawee?
Yes.
And did you have in your possession cocaine?
Yes.
Did you know it was cocaine?
Yes.
Okay, did you have any legal right to possess it?
No.
All right, are you satisfied, Mr. Banetto?
Yes, sir.
Has the court complied with MCR 6.302 B, C, and D? Mr. Glazier,
Yes, Your Honor.
Mr. Banetto?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights, and she does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. September 6th of 2024 at 8:15. Are you available that day, Mr. Glazier?
Yes, Your Honor.
All right. So I guess before I go any further, you wanted to address bond?
Yes, Your Honor, we had never asked for a PR bond in this matter. My client was serving 45 days out of district court or something.
Yeah, for child support.
For child support. And her time is up on that as of the 13th. We'd ask if you'd consider.
I'll drop and everything.
We'd ask if you'd consider a PR bond pending.
Okay. All right. Mr. Banetto?
Your Honor, I have not had an opportunity to run the guidelines on this. I don't know what she's going to score.
They're going to be low because it's possession cocaine.
Correct. There is a prior absconding as well, though, so I am not sure. I did try to reach out to Mr. Glazier yesterday. We weren't able to connect, so I'm not really prepared to argue bond at this point, but I think it might be premature, but ultimately I'll defer to your Honor's.
All right. So let me get Mr. Coast. He's our pretrial services coordinator and he can.
Hi, Judge.
Hi, Mr. Coast. So I have Samantha Barrett, who
Okay.
just entered a plea on a possession cocaine case, and I'm going to be releasing her on a PR bond.
Okay,
But I would like you to monitor her. She's in jail right this moment and she's here at the courthouse. So I didn't know if you wanted to chat with her
yeah.
down
actually-
at lockup.
Yeah, I'll do that, Judge, and I'll have her set up on colors.
Okay, so
Thank you.
in just a second, we're gonna be sending her down to lockup.
Excellent, thank you.
All right, thanks, bye.
Bye.
You'll actually walk by his office, but, okay, so, Ms. Teskey will need contact information. So when you get out of jail today, I need you to come back to the courthouse and I need you to report to third floor probation. And they'll give you a packet and then you're gonna give them your contact information.
You want me to, do you want me to just come here right after I get out?
When you get out of jail, walk across to the courthouse and come in.
Okay.
We're closed from, what is lunch, Ms. Teskey, 12 to 1 or something? But you need to check in, give him your contact information, get your packet to fill out. Make sure you, yeah, third floor.
Is
So,
there a testing?
yeah,
Okay.
be truthful when they'll set up a time to meet with you. Make sure you show up for that.
Yes, ma'am.
Be truthful about your background, the events that occurred. They'll prepare a pre-sentence report. We'll provide that to Mr. Glazier. It's your responsibility to contact Mr. Glazier a week or two before sentencing to review that with him, okay?
Problem.
And then do you want to be in person or via Zoom for sentencing?
Via Zoom is fine.
Okay,
Thank you.
so I'll put that via Zoom.
I have one question. I have, paying fines downstairs and I'm supposed to pay every Friday. I don't got a bench warrant for that, right? Because I've been in here.
I would have no idea. I'm not district court.
All right.
I don't even have access to their
Oh, you
system.
don't?
No,
But they'll fix it if so, because I've been in jail.
I don't know what
Okay.
district court does. Mr. Glazier
Okay.
probably can give you a better idea of what they do down there.
Yeah, I don't know what to do.
Okay.
Just for the record, John, I did send an amended information to the court. just
Okay.
now, So.
And you guys will file that across the hall?
Yes, sir. I
Okay.
sent that to Ms. Aranda.
Okay. All right, so, all right, Ms. Barrett, you're all set, and Mr. Coast will speak to her before you take her.
Thank you.
Thank you.
Thank you.
Thank you. All right, so. Mr. Malaro, I have Sherrod Gant, and I have. oh, Mr. Vanzo's here, but he didn't need to be here. Do you want to take Sherrod Gant? Zoom. Mr. Vanzo, can you hear me?
Yes, ma'am.
All right, in the matter of the people of the state of Michigan versus Jamie Allen Vanzo, file number 2023-21503FH. Mr. Vanzo, your hearing is being adjourned to July 31st at 8:30 in the morning, okay?
July 31st. Okay.
Yeah, at 8:30 in the morning. Thank you, Mr. Vanzo.
Thank you very much. Thank you.
All right, thank you. All right, I got the jail popping. All right, so Mr. Sherrod Gant, can you hear me? Okay, and Mr. Wallace, I'm gonna change your screen name. And you have Rhonda Underwood, right?
Yes.
All right, she is next door at Judge Olsaver's, so I'm changing your screen name and I'm gonna pop you in the waiting room and it shouldn't be too much longer, okay?
Okay, thank you.
Thank you. Sherrod Gant, can you hear me?
Yes, ma'am.
Okay, good. Mr. Gant, thank you. So this is in the matter of the people of the state of Michigan versus Sherrod Rashawn Gant, file number 2024-21791FH. I have Salvatore Malaro appearing on behalf of Mr. Gant, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial in this matter. So, Mr. Malaro, how would you like to proceed today?
Judge, I'm gonna ask to adjourn this one more time briefly, even a week would be fine. I have not been able to, due to my schedule, make sure Mr. Gant and I are on the same page about a plea.
Okay. Would August 7th be okay, 2 weeks?
Yeah, August 7th is fine as well.
All right. So, Mr. Gant, I'm going to adjourn this to August 7th at 8:30 a.m. and I need you to make sure you reach out and call Mr. Malaro, okay?
Judge, it's not on his.
No, I'm not. I know it's not his fault or your fault. I just always remind him. Okay. So August 7th at 8:30, Mr. Malaro, you'll do the step in order.
Yeah, and Judge, if we can nail down the plea offer and agreement, could we come in earlier than that?
Yeah, you can, anytime a plea offer has been struck and you want to take it on a day other than a Wednesday, that is awesome for me.
And are you available at any time next week?
No, but Judge Olsaver is.
Okay.
I'm gone next week.
Later this week?
I'm here all week,
Okay. Thank
but
you.
Judge Olsaver would take the plea.
Okay.
Okay. All right, so you're all set, Mr. Gant. Thank you.
All right, thank you.
All right, Ms. Malatirno, Mr. Regalado, can you hear me?
Yes, ma'am.
All right, Ms. Malaterno, I have Mr. Regalado.
Yes, Your Honor.
All right, this is in the matter of the people of the state of Michigan versus Mark Shane Regalado, file number 24-21763FH. I have Isaac Sneed appearing on behalf of the people, and I have Diane Malaterno appearing on behalf of Mr. Regalado. The plea offer I have in my file is plea discharge, no subs, and just nolly pros any misdemeanor. So, Ms. Malaterno, how do you wish to proceed today?
Your Honor, I had a bad Zoom connection with Mr. Regalado yesterday, so if I could have a breakout room just for a moment, I would appreciate that.
Not a problem. So, Mr. Regalado, I am going to open up a breakout room and assign you and Ms. Malaterno to that breakout room. There you go. You know how to join it? There you go.
Thank you.
All right, let's see. I have Mr. Fanslaw. Do I have anybody else in the courtroom that's a defendant? No? All right. Mr. Lyons, do you know where Mr. Ross is?
I actually do. You now know to usually study that.
Okay.
That's where I was.
Okay. Okay, not a problem. All right, so while they're having a brief chat, we'll take.
I mean, I didn't say.
I'm ready on Mr. Fanflow and Eric Miller.
I don't have Erica Miller.
Yes, she's here.
Where?
Yeah.
Oh, okay. All right, so Mr. Fanslaw, you want to come up? Right, we are back on the record in the matter of the people of the state of Michigan versus Brian Fanslaw. File number 24-21760FH. We have Matthew Murphy appearing on behalf of Mr. Fanslaw, and I'm going to go with Alexander Bayonetto on behalf of the people I couldn't remember.
Yes, Your Honor, I apologize.
So this is the date and time set for pretrial. Mr. Murphy, were you able to?
Yes, Your Honor. The offer from the prosecution would involve Mr. Fanflow pleading to an OWI third, a felony with entrance into sobriety court. Anything further would be left up to the court's discretion in regards to sentencing. And so at this time, Mr. Fanflow does wish to do that. Does wish to enter a plea of guilty to OWI third.
Okay, so Ms. Teskey, typically he's been admitted to sobriety court. Ms. Teskey, when you guys prepare the pre-sentence report, that is with the interaction of those individuals from the sobriety court program, correct?
I'll write the PSI. I will supervise him with MDOC, and he will also have a probation officer in district.
But I mean, the recommendation will be in conjunction with what the sobriety court would like done with them. Yeah, so do you understand that? Even though I'll be sentencing you, I will take input from what the people in the sobriety court program would like to happen at sentencing. Do you understand that?
Sure.
Okay, all right. Anything else, Mr. Murphy?
Nothing further from the.
All right, Mr. Fanslaw, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? So you're soft-spoken, so step up to the microphone.
Yes, Your Honor.
Okay, very good, and just kind of speak louder for me. So, Mr. Fanslaw, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count one, operating while intoxicated, third offense, which carries a maximum penalty of up to from $500 to $5,000 in fines and costs, in either 1 year to 5 years in jail or prison, and probation 30 days to 1 year in jail? The minimum requirement is that you serve at least 48 hours consecutively in jail. So 2 days in jail is a minimum requirement. Do you understand that?
Yes, Your Honor.
Sometimes people serve that when they get arrested. I don't know what your credit is. And then you can be ordered to pay up or to serve from anywhere from 60 to 180 days community service, as well as cost of reimbursement for government expenses. Do you understand that?
Yes, Your Honor.
Are you satisfied with your attorney and the advice that he's given you?
Yes, Your Honor.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any possible sentence with the court. Is that correct, Mr. Murphy?
Yes, Your Honor.
Mr. Bayonetto?
Correct.
Is that correct as far as you're aware?
Yes, Your Honor.
If a guilty plea is admitted or accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
How do you wish to plead to the charge that on or about February 20th of 2024 in the city of Tecumseh in the county of Lenawee that you did commit the offense of operating while intoxicated, third offense? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Murphy?
No, Your Honor.
Mr. Bayonetto? Has your attorney promised you any particular sentence or estimated what your sentence will be?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
So, Mr. Fanslaw, on February 20th of 2024, were you in the city of Tecumseh in the county of Lenawee?
Yes, Your Honor.
Were you operating a motor vehicle? All right, and had you been drinking? And would you agree that your blood alcohol content was 0.08 grams or higher? So you were over the legal limit. Okay. Now you have a prior conviction on June 23rd of 2015 in Tawas City District Court. Is that correct?
Yes, Your Honor.
And then you have another one on September 17th of 2013 in Tawas City District Court. Is that correct?
Yes, Your Honor.
Okay. All right. Are the people satisfied?
Yes, Your Honor.
Has court complied with MCR 6.302 B, C, and D? Mr. Murphy?
Yes, Your Honor.
Mr. Bayonetto?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. I am going to set sentencing for September 6th at 8:15. Are you available that day, Mr. Murphy?
Yes, Your Honor.
And Miss Adams, could I get a notice of hearing for Mr. Fanslaw? So
Yes, is that
September
in
6th.
person? I missed
Do you
it.
want to be in person or via Zoom?
In person.
Yeah, in person. And it's Mr. Fanslaw, September 6th at 8:15. So, Mr. Fanslaw, I am going to send you directly across the hall to the Michigan Department of Corrections. Go in, check in at the front counter. They'll give you a packet to fill out. They'll set up, get your information from you, and they'll set up a time for you to come meet with them. It's very important. You turn that packet back in, you come in and meet with them. When you meet with them, be truthful about your background, your sobriety issues, as well as the events that occurred that night. They'll prepare a pre-sentence report. Mr. Murphy will get a copy of that. Make sure you reach out and contact Mr. Murphy a couple weeks before sentence to review that with him, okay? And then we'll see you back here on September 6th at 8:15 in the morning. and you continue the AA and all the other requirements with Mr. Coast, okay? All right, very good. Thank you. Anything else, Mr. Murphy?
Nothing further, Your Honor. Thank you.
All right, thank you. All right, I got Mr. Regalado back.
Yeah, he's gonna get a notice, correct?
Yeah, just have a seat. We'll get you notice. Sit there by Mr. Murphy. All right.
Did you tell him to report to probation, Judge?
Say it again, Ms. Teskey.
Did you tell him to report over here?
I did.
Okay, thank you. I missed it.
Are you watching TikTok and ignoring me again?
No, I don't do TikTok.
That's a shame. I love TikTok. All right. So, Mr. Regalado, we're back on the record in the matter of the people of the state of Michigan versus Mark Shane Regalado. File number 24-21763FH. So, Ms. Malaterno, have you had a chance to speak with Mr. Regalado?
I have, Your Honor.
And how would you like to proceed with Mr. Regalado?
Mr. Regalado would accept the plea. Since it was a few minutes ago, I just want to repeat it's as charged on the felony with no stops. Dismiss district court cases 231889, 231939.
Okay, is that a correct recitation of the plea, Mr. Bayonetto? It's what I have on my file.
Mr. Sneed.
From the list. Oh, Mr. Sneed. It's what was in my file, so I'm assuming. Mr. Sneed.
You just have a moment, Your Honor.
Yeah. The note I had in my file was plead as charged to count 1, no habitual. And then whatever the misdemeanor was would be nully crossed down in district court. So it would remain a 5-year felony.
Yeah, that's correct, Your Honor. Thank you.
All right. Okay. All right, Mr. Regalado, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, so Mr. Regalado, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, retail fraud, first degree, which carries a maximum penalty of up to 5 years in prison and or a $10,000 fine, as well as 3 times the value difference in price of property stolen, obtained, whichever is greater. So is it you can put your hand down. It's okay. So is it your intention to plead guilty to count 1?
Yes, Your Honor.
And count 1 carries a maximum penalty of 5 years, but the habitual offender 4th offense notice will be dismissed. So potentially if you'd been convicted at trial, you understand you would have been looking at life in prison.
Yes, Your Honor.
All right. So, and I think you said you're satisfied with your attorney, correct?
Yes, Your Honor.
All right. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, it is, Your Honor. Thank you.
And Ms. Malaterno?
Yes, Your Honor.
And Mr. Regalado, is that correct as far as you're aware?
Yes, Your Honor.
Okay, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation exclusion from admission to the United States of America, or denial of naturalization. Mr. Regalado, do you have any questions about the rights that I've given to you?
No, Your Honor.
All right, so Mr. Regalado, how do you wish to plead to the charge that on or about January 12 of 2024 in Madison Township in the county of Lenawee, that you did commit the offense of retail fraud first degree, guilty or not guilty?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor.
Ms. Malaterno?
No, Your Honor.
Mr. Regalado, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, Your Honor. The only thing I heard that there might not be like restitution because I didn't take anything out of that store. That's the only thing that I heard. I don't know if I have to pay because I didn't leave with nothing out that store.
Oh, okay. All right. So it's your own choice to plead guilty?
Yes, Your Honor.
All right. So Mr. Regalado, on January 12th of 2024, were you at Walmart?
Yes, Your Honor.
And would you agree that's located in Madison Township in the county of Lenawee?
Yes, Your Honor.
All right. So at that time, did you steal property that had a value of more than $200, but less than $1,000? Now, I understand you didn't get away with it, but did you steal it?
I left it in the store.
Okay. So when you were in the store, were you pushing a cart?
Yes, I was pushing the cart. My intention was to steal it. And I left it there though in the store. I didn't leave the store with it.
Okay. So would you, what were you going to steal? Was it a big screen
Food.
TV?
Food. No, food. It was all food. Food,
Okay,
Your Honor.
food's expensive these days. So would you agree it was worth more than $200?
Yes, Your Honor, it was. Yes.
All right. And your intention was to steal it, but you were thwarted. You
Yes,
weren't able
my
to.
intention was to steal it. Yes, not to pay for it, to take it. Yes, it was.
Okay. Okay. Are you satisfied, Mr. Sneed?
I am. Thank you, Judge.
Okay. Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, Your Honor.
Ms. Malaterno?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to set this matter for sentencing on September 6th at 8:15 in the morning.
Your Honor, could we also address bond today?
Sure. Go ahead.
Yeah, Mr. Regalado, since he has taken responsibility for his actions, was hoping to have his bond reduced perhaps to $100. I think he said it's at $500 right now. He's got a newborn baby at home. He does have 8 kids at home to provide for. So he could be working between now and his sentencing date.
Mr. Regalado, when's the last time you had a job?
Your Honor, I roof, Your Honor, but I get paid underneath the table, Your Honor. That's how I'm married and I have 8 kids. My wife may come be with no one who doesn't work, you know. I work.
So
but
when was the last time you had a job? Where were you
before
working
I
at?
came here, I had a job June 3rd. I got arrested. I was on my way to turn myself in to the jail. An officer seen me and arrested me. I was working then, June 3rd of this year. I was roofing for Cantu Roofing. They work with Wachovia Roofing. That's what I do. I'm a roofer, Your Honor.
Okay, that's all I was asking. Mr. Sneed, he's been in custody for about, 6 weeks. So what is your position, Mr. Sneed?
Your Honor, people would defer to the court. Thank you.
Mr. Regalado, you don't have a tendency to run away from me. So I am going to give you a PR bond, Mr. Regalado.
Okay.
But listen to me. If you don't comply with what I'm going to tell you to do, then I'm going to issue a bench warrant, all right?
Okay, Your Honor.
All right. So when you get out of jail today on that PR bond, you're going to walk. You're not being held on anything else, are you?
I'm not sure about, I had a court date with, Mr. Morgan on August 8th, Your Honor. That's what I don't know.
Okay, well, I don't know. Do you want me to release you today on mine, but you might still sit in jail on that one? Miss Malaterno, do you know anything about that one?
He was actually looking for a reduction to his bond to $100. He does have a contempt of court that will be dealt with. I suspect Mr. Morgan will dismiss it, but I'll try to get that moved up. That's why he was looking for a bond reduction of $100 to $100.
All right, I'll reduce, never mind, I'll give you $100 bond, cash bond. And so I'll reduce to that. Mr. Regalado, if you get out of jail and it's a weekend, Monday morning at 8 o'clock, I need you here at the courthouse to the circuit court probation department. If you
Okay.
don't get out of jail, someone from the probation department will come meet with you, but this is circuit court probation on the 3rd floor. So if you get out of jail, first moment available to get to the courthouse, you need to come in and check in with them. They'll give you a packet, set up a time for you to come meet with them. When you meet with them, be truthful about your background, the events that occurred. They'll prepare a pre-sentence report. I'm setting your sentencing for September 6th at 8:15. Do you want to appear in person or maybe Zoom? What would you like?
Person, Your Honor, because most likely, Mr. Morgan, I mean, like, I know I have a contempt of court or something, but I have a question, Your Honor. Since the misdemeanors got dismissed, when my bond go down from district court, since my charge has been dismissed?
If you have a contempt of court, that stays.
Yes,
So
but I know
even if
that. But it's,
so, I don't know. I'm not a
I don't know. I
district
just don't
court
like.
judge. Mr. Regalado, hold on.
I'll deal with it, Mr. I'll deal with it, Mark.
All right.
Yeah, I'm not a district court judge. I don't know what their procedure is down there. Your attorney would know. But I know that just because they dismiss a case doesn't mean the contempt of court goes away. So.
No, I know
All
that.
right,
I know
so
that.
I'll reduce your bond to $100 cash. If you get out of jail, immediately report to the probation department. If you don't get out of jail, they'll come talk to you.
Okay.
And then your paperwork from the jail will have your sentencing date on it. Don't lose that paperwork and make sure you show up for sentencing, okay?
Yes, ma'am. Yes, ma'am.
All right. All right, and you're all set. Thank you.
Thank you, Your Honor.
Thank you.
Thanks, Ms. Malaterno. All right, let's see what we got. So I have a gentleman from the jail. What's your name? Not Mr. Regalado. Jail room number 1. Oh, Mr. Johnson? Okay. Mr. Malaro, I have Troy Johnson.
Ready, Judge.
All right. So let me grab your file. This is in the matter of the people of the state of Michigan versus Troy Tabell Johnson, file number 23-21597FH. I have Salvatore Malaro appearing on behalf of Mr. Johnson, and I have Isaac Sneed appearing on behalf of the people. This is date and time set for a pretrial as well as contempt of court hearing. So, or pretrial as well. So, Mr. Malaro, how would you like to proceed on behalf of Mr. Johnson?
Judge, Mr. Johnson's charged with possession with a supplement, which makes it a 20-year felony. Mr. Sneed is an habitual for it. Mr. Sneed has made an offer that would be plea to the possession with the sup. I need to talk to Mr. Johnson about that to see if he wants to do that. But in the meantime, I'd like to set the matter for trial, just in case we cannot get this resolved.
All right. So, Mr. Johnson, you are currently charged with possession of methamphetamine, which is a 10-year felony, but you have a drug sup, which makes it a 20-year felony. But you also have a habitual offender 4th offense notice, which takes that 10-year possession of methamphetamine and makes it a life offense. So if you were convicted, do you understand you could potentially be looking at life in prison?
Yes, ma'am. Yes,
all right. And Mr. Malaro just stated that the plea offer that was made was to plead to count 1, possession of methamphetamine. Is that with 1 sup making it a?
Makes it a 20-year, Judge.
So it would be the drug sup, not a sup.
Correct.
Okay.
At least that's what Unless I misunderstood Mr. Sneed.
So Mr. Sneed is and just from my notes, I have one sub. So would it be just the 10-year possession of methamphetamine with one habitual sub, making that, I don't know, what is that, a 15-year? Or is it the drug sub?
Your Honor, the offer would have him plead as charged to the possession of meth with the controlled substance sub, and the people would dismiss the habitual force sub, and also we would not charge absconding.
Okay, so Mr. Johnson, that means that the maximum penalty would remain 20 years. It's a drug charge, so the guidelines aren't incredibly high on that. And then your absconding charge would not be filed because you have enough to be charged with absconding, and the people won't charge that. Do you understand that?
Smooth.
Okay, and your attorney is asking for a pretrial, so I'm going to set this for another pretrial for you two to discuss that. So, Mr. Malaro, how far out would you like a pretrial?
As short as possible, Judge. I'll go see him this week.
Okay.
Find out what he wants to do.
So, my next available, I can do August 7th.
That's fine.
Okay. So, Mr. Jensen, I'm going to set this over to August 7th at 8:30 for a pretrial, okay? All right, and I'll continue the contempt court as well. So, all right, so Mr. Mallory, you do the step in order?
Yes, Your Honor.
All right, so Mr. Johnson, I'll see you back on August 7th.
Excuse me. Well, he said that I was gonna try to give me a bond reduction. See what to do with it.
So, your attorney has repeatedly asked for a bond reduction, but you just have not ever showed up for my court. So I denied it previously. Is that correct? Because you failed to appear on November 29th of 2023. And then I didn't see you again. And then there's a violation of bond conditions back from November 30. And then there is a show cause for violation of bond conditions before that.
It'd be prudent to request a bond reduction, given the fact that there's an absconding pending. I don't want to compound the issue. I didn't think it was prudent.
So, do you want to make a formal request on the record, Mr. Malone, again?
I can. Your Honor, Mr. Johnson, I've handled some matters for him down in district court. He did appear for those. One was they charged him as opposed to his son. It was really his son that ultimately got dismissed. So he's appeared down in district court for me. I was kind of surprised when he didn't appear in this case. He's always stayed in contact with me. I suspect the issue is the use of controlled substances, which I think the court could address with testing conditions, and I know that's been done in the past. So I would ask the court to consider a reduction.
All right, people wish to weigh in.
Your Honor, the court denied this request 3 weeks ago. I don't think anything has changed. I'd rely upon my arguments made at the last pretrial conference. I hope we can resolve this matter in August. Thank you.
Okay. So I am going to deny the request for bond reduction. But Mr. Malaro and Mr. Johnson, if a plea agreement, if Mr. Johnson decides to take a plea agreement, obviously I'll take you in any day to get you moving. And then I am willing to revisit bond at the time of that. All right.
Thank you, Judge.
All right. So Mr. Johnson, I'll see you back on August 7th, if not sooner. Okay.
Hey, man.
All right. Thank you, Mr. Johnson.
I have a question for you. If they say I have a problem, if they say I have a problem with drugs, why can't I go to a real
Mr. Jensen, for some reason, the audio's kind of wonky in your room. So can you kind of scoot forward a little bit and say that again?
If they say I got a problem with drugs, why can't I go to 4211 or go to a pre-program or something? If I got a problem with drugs.
So Mr. Jensen, again, for whatever reason, hold on, maybe sit back, try it again. I just wasn't able to hear you.
Can I get to a program or something? Or something? If I got a jail program or something? Can I get a program?
Mr. Jensen, I want to apologize. Go tell them that the audio is bad in that room, and could you sit in another pod to talk to me?
Okay, okay.
I'm so sorry. Okay, was it just me? The audio is bad, okay, okay.
So the audio is not too full. This is the audio. Let's get the room. Can you hear me now?
It's really garbled, so I don't know if it needs to be shut off and restarted, because I could hear him earlier. Or I have Jail Zoom 6 open. I don't know if he can go to a different pod and maybe shut that down and restart it.
You can do that, ma'am.
I can't hear her either. So.
She said they can do that, ma'am.
Yeah. I'm always hoping it's not me because I'm not ready for hearing aids yet.
Could be testy, dude.
Hello?
Okay, so much better. All right, I'm sorry, Mr. Jensen. Go ahead. Now, what were you
Yeah,
trying to say?
I said, can I get you a program or something? At least that?
So that'll be part of your sentence, and we'll look into that. Okay.
Okay. Okay.
All
Because
right.
I got a son that need a kidney real bad. And I want to try to see if I can get out there to get him a kidney. Because he's on dialysis right now and they don't know if he's gonna live or not. And if I'm a make for him, I live my life. If I'm a make for him, I'm cleaned up all the drugs. I ain't trying to stomach and do no more time, to be honest. I've been here long enough. I'm pushing 50 this year. And I got a son that's born 94. He's my oldest boy. And he's dying off of a kidney that he needs for a donor. And I don't want to know if I'm gonna make for him. If I'm gonna make for him, then I'm gonna give him my kidney. If I can give him both of my kidneys, I will. You know, that's what I was trying to tell my. Didn't tell my lawyer nothing. So I'm talking for the behalf of myself, to being really honest. And I'm like, yeah, I made a mistake. Yeah, I ain't mad. I made a mistake, but I'm willing to be a man and take care of it and handle it because
Okay.
my son needs me.
So, Mr. Jensen, your attorney is going to come see you, and if we can get you in sooner, we will. I mean, obviously, you want to be a match. I don't know that you can be a match anymore because of your drug use. So
Yeah, but
that's
I've been clean ever since I've been here since March. I don't got no choice of doing it.
I know.
Because I got God in my life now.
So, Mr. Jensen, I appreciate that, and Mr. Millar will come meet with you, and if we can get you in ASAP, we will, and we'll address bond again, okay?
Okay, thank you, ma'am.
Thank you.
Thank you.
Rhonda Underwood, I do not have, let's see, I have Michael Robinson, Miss Underwood. Are you gonna need a breakout room with him?
Yes, please.
Okay, all right, so I got Scott Rogers.
What about?
Is that you, Mr.
Yes, ma'am.
Mr. Millar, are you Scott Rogers?
Yes,
I got him too.
Oh, I didn't see it.
What
All right.
about Mr. Wallace, Your Honor?
Mr. Wallace was here like at 8 o'clock, and then I told him to come back at 8:30, and he's in the waiting room. Okay, so, let me get Mr. Robinson's file. This is in the matter of people of the state of Michigan versus Michael Dwayne Robinson, file number 24-21698. FH. I have Brenda Underwood appearing on behalf of Mr. Robinson, and I have Isaac Sneed appearing on behalf of the people. I have a note in here that we don't have fingerprints. He's an MDOC. How do I not have fingerprints? I mean, whatever. So I do have a forensic update for evaluations dated May 22nd of 24. They said that the reports are in progress, and I did get the report on, okay, so June 13th of 24, they completed their report. I have it set over for today. Did we already put that on the record? Yes, no. So I guess we need to put the report on the record today, Ms. Underwood?
That's correct, Your Honor.
All right, Mr.
Why don't
Sneed,
we
did you
start
receive
with
that as
that?
well?
Yes, I have. I have no objection to the court reviewing it, Your Honor.
All right, and
No
you
objection,
stipulate
Your Honor.
to, all right, and you both have no objection to admission of this report.
That's correct.
Yes, Your Honor.
So I have received a report on June 13th of 2024 from State of Michigan Department of Health and Human Services Center for Forensic Psychiatry. It is written by, get back there. It's a long one. It is written by two people, I guess. Derek Stodolak, MD, JD, forensic examiner, diplomat in psychiatry, American Board of Psychiatry and Neurology, and Martha Smith, degree of psychology, ABPP, licensed psychologist, consulting forensic examiner, board certified in forensic psychology, American Board of Professional Psychology. So I have finding on the competency that says Mr. Robinson does have a current diagnosis for which he is receiving treatment. There's some acknowledgement that working with Mr. Robinson could be challenged due to his low tolerance for frustration, tendency to become behaviorally dysregulated, and oppositional defiance disorder traits. However, in summary, it is my opinion that Mr. Robinson was not incapable because of his mental condition of understanding the nature and object of the proceeding against him or assisting in his defense in a rational manner at the time of the interview or the current evaluation. Therefore, while I respectfully acknowledge the ultimate decision in this matter depends on judicial determination, it is my opinion that Mr. Robinson was competent to stand trial. I also received a June 13, 2024 report regarding criminal responsibility to advise the court that the evaluation of defendant's competency to stand trial has been issued under separate cover. However, the criminal responsibility evaluation was unable to be completed as the defendant declined to participate in the court-ordered evaluation. So, Ms. Underwood, I guess at this point, I would ask people to prepare the order for competency so I can sign that, deeming that he is competent to stand trial. Ms. Underwood, is there anything you'd like to add to that?
No, Your Honor.
All right, and at this point going forward, again, I don't know how he's not been fingerprinted because he's at NVOC, but we'll figure that out. So the plea offer in this file, Ms. Underwood, is to plead as charged, no subs, and his habitual offender fourth offense notice would be dismissed. Mr. Robinson, you're charged under count 1 with assault of a prison employee, which could carry a maximum penalty of up to 5 years in prison and or a $2,500 fine, although you're incarcerated, so I wouldn't assess that. $2,500 fine. That's a 5-year felony. Now, Ms. Underwood's going to talk to you in a minute about that, but you also have a habitual offender fourth offense notice, which means that if you were convicted at trial, you could be looking at life in prison. So, Mr. Robinson, I'm going to open a breakout room and give you a chance to talk to Ms. Underwood. You were asking for that, right, Ms. Underwood?
Yes, Your Honor. Thank you.
Okay. And then, Mr. Robinson, when you're done talking with Ms. Underwood, you will come back in and we'll proceed with the hearing. So, all right, so you'll probably go automatically because I think you're on a polycom. All right, there's, okay. All right, Mr. Rogers, is your client here? Oh, he is here? Okay, I'm sorry. So, Mr. Rogers, hold on one second.
Your Honor, when the court gets a second, can Mr. Murphy and I approach up something else?
Sure. This is in the matter of the people of the state of Michigan versus Scott Allen Rogers. We have two files, 24-21764FH and 24-21815FH. I have Salvatore Malaro appearing on behalf of Mr. Rogers. Mr. Rogers is joining me via Zoom from the jail, and I have Isaac Sneed appearing on behalf of the people. Mr. Malaro, how would you like to proceed with Mr. Rogers?
Your Honor, I'm going to ask to adjourn this matter. Basis is we put in for some medical records, and I'm told that the medical facility is in process of getting them to us to certainly help in determining which direction this case will go.
All right, so Mr. Rogers, I'm going to set this over to September 4 at 8:30 in the morning. And Mr. Malaro is really good about, if this gets resolved ahead of that, he will have you brought in sooner. So you'll do the stip in order to adjourn?
Yes, Your Honor.
All right, so we'll see you back, Mr. Rogers, on September 4 at 8:30 in the morning, okay?
Thank you.
Thank you. Okay, Mr. Lyons. I'm sorry, I did not know your client's here. Okay, so this is in the matter of the people of the state of Michigan versus Nathaniel Eugene Ross, file number 24-21794FH. I have George Lyons appearing on behalf of Mr. Ross, and I have Isaac Sneed appearing on behalf of the people. So I have an issue with your client today.
I understand.
So I received from Darren Coast, who is on Zoom, a show cause, and it was switched to a bench warrant because of him blowing ridiculous numbers. So defendant on this motion affidavit and bench warrant states defendant tested positive for intoxicants on his remote breath machine on June 29th of 24, 0.033% at 12 p.m., a 0.024% at 12:15, and a 0.021 BAC at 12:47, 0.018 BAC at 1:02 p.m., and again on July 13th of 24, 0.031 BAC at 12, 0.032 at 12:15, 0.027 at 12:52 p.m., 0.019 at 1:29 p.m. And hold on, is that the only one? Yep, and that's on both files.
I only have one of those, Your Honor.
Yep, that's a new one. And then there was the other one. Hold on. Let's see. Is there anything else, Mr. Coast?
Judge, I believe that's it. There's been two separate incidences, one on June 29th and then July 13th.
Okay, so Mr. Lyons, your client is here on carrying a concealed weapon and operating with a high BAC. So the high BAC obviously is a misdemeanor, but his bond condition is he's not supposed to consume alcohol. So I've signed the warrant. So I guess I'm going to ask for input, Mr. Lyons and Mr. Sneed on that.
Respectfully, Your Honor, I wasn't aware of the second file.
Do you want to see it?
No, the court's read it into the record, Your Honor. We're satisfied with that. Respectfully, Your Honor, he came here today to take responsibility. There is an explanation. There's a causation, not an explanation. And he is making plans. If he leaves here today, I'm going to begin to engage in AA meetings. But first of all, he's going to take responsibility.
Okay.
The numbers are disturbing.
Okay. All right. So is he going? So he's pleading on the underlying file?
Your Honor, we haven't actually even had a chance, haven't talked to the prosecutor about resolving the underlying file yet. I would love to give him some time, if the court is of a mind, to release him back on bond with the instructions to attend AAs and things like that, to give the court some idea that he's taking this stuff seriously, then I like the interview, if it makes sense.
Okay. All right, Mr. Sneed, has a plea offer been made on this file?
Your Honor, we had discussed a misdemeanor reduction if he forfeited the weapon and obtained a CPL for the CCW. The defendant has a minimal record and he was cooperative at the time of the arrest. I think these bond violations come as a surprise to Mr. Lyons and myself. So
okay.
I believe we can resolve this matter short of a trial.
I'm certain that too.
So, Mr. Lyons, you're here. Do you want to chat with Mr.? I mean, I know you're a very busy man.
Well, I'm supposed to be in trial for the next 2 weeks, so I've got a little.
Well, actually, you're not because your trial fell out. So I didn't know if you wanted, I'm here all day.
I would like to resolve it, Your Honor, as we had discussed. Is that still on the table, given this, given?
They don't, yeah. So what would be the misdemeanor, Mr. Steen?
Your Honor, we didn't come up with the exact one, but I think with time we can resolve it. So.
Okay, I didn't know if maybe there was, like, we could have a meeting this morning and try to resolve it while everybody's here. So, okay. So Mr. Robinson is in the waiting, or he's still in the breakout room, Miss Underwood. I'll bring him back in 1 minute. All right, so Mr. Ross, you know, obviously it sounds like you don't have a big record. And the plea offer sounds like it's going to be a very good plea offer, but you have to stick with our bond conditions. You know, and what could happen is if you violate the bond conditions, again, I could lock you up until this case is resolved. Because judges don't like when people don't follow their orders, right?
Right.
So I know you're an adult and I don't know what happened and what explanation your attorney is gonna give me, but I'm gonna set this over to the next pretrial and you're gonna work with Mr. Coast. And is he doing twice daily PBTs? What is he doing, Mr. Coast?
He is, Judge, he's doing twice daily. It looks like it's noon and midnight.
Okay, so you understand no more violations?
Yes.
Because if there is, I'm gonna issue a bench warrant.
Okay.
And then you're gonna sit in jail. Our jail's not that nice. You can't go outside, you know, I don't know. So, all right, so I'm gonna set aside the bench warrant and I'm gonna leave it in, I'm gonna enter a plea of not guilty on those. But Mr. Coast, obviously, if there is one more violation. I will issue a bench
Absolutely,
warrant.
Judge. Judge, would you like to order daily AA on this?
What is your work schedule?
Second shift, 3 to 11 p.m.
Okay, I would like at least he has no prior alcohol offenses.
And even the weapon that was found in the car was his. He just didn't have, he wasn't carrying it properly, nor did he.
Yeah, you need to work on that CPL right now. All right, so I'm gonna order 3 AA meetings a week. And you live in Jackson, so there's quite a few around the city. Okay, so I'm gonna order 3 AA meetings a week. Because the thing is, if you know you're not allowed to drink and you're still drink, that means you might have a problem, right? Because you can't, no self-control. So 3 AA meetings a week, continue twice daily PBTs. I don't want to see another violation. How far out would you like a pre-trial on this, Mr. Lyons?
Yes, ma'am.
A month?
That sounds good. Yes.
How about September 4 at 8:30 in the morning?
That sounds like a good game.
All right. And I'll give you a PR bond on those contempt courts. All right, and Mr. Lyons, I'm gonna do the notice because he's here and I like to give him notice in person. So Miss Adams, could I get a notice for Mr. Ross for a pre-trial on September 4 at 8:30 in the morning?
Yeah, I'm gonna have him sign his PR bond.
Yep, and then you gotta sign your bond because I'm not taking you into custody today.
Right, would you like him to meet live or via Zoom?
Do you wanna, I don't care. For pre-trials, you can do whatever you want. So,
Thank you, Judge.
all right, Darren Coast, you need to meet with them this morning.
I do. And Nathaniel, I'll meet you out in the hallway there because I want to go over the AA requirement with you.
Okay, so have a seat. We'll get you a notice of hearing, Mr. Lyons. Always a pleasure. And
Thank you for your patience.
no problem.
Thank you.
Okay, so I'm gonna bring Mr. Robinson back. Okay. Hold on, Mr. Robinson's coming back. There he is. Okay, Okay, Miss Underwood, have you had an opportunity to speak with Mr. Robinson?
I have, Your Honor.
All right, and how would you like to proceed today on behalf of Mr. Robinson?
Your Honor, we have not arrived at a plea bargain today. I would, I guess, ask the court to either set another pretrial or set this matter for trial, Your Honor.
So why don't we set another pretrial for September 4 at 8:30 in the morning? And at that time, if there's no resolution, we can set it for trial. How's that?
Thank you, Your Honor.
And you'll do the stip in order to adjourn?
I would be happy to with Mr. Sneed's permission.
Okay, Mr. Sneed.
No objection. Thank you.
What date was that, Your Honor?
September 4.
Thank you.
So, Miss Underwood, I'm going to take Mr. Wallace next, but I do not have an AG.
Mr. Owutu-Coker was here earlier, Your Honor.
Well, he was down in front of Judge Olsaver, right?
Yes.
Well, he didn't come to see me. Yep, Mr. Robinson, you're all set. You have a good day.
Okay, you too.
Thank you. Well, Mr. Owutu-Coker went to see Judge O and he didn't come to see me, so. It's okay. All right, Mr. Wallace, thank you. This is in the matter of the people of the state of Michigan versus Benjamin Ray Wallace. File number 22-20838FH. I have Rhonda Underwood appearing on behalf of Mr. Wallace. Mr. Owutu-Coker was here this morning. He's just not in my court this morning. So, Miss Underwood, I'm assuming Mr. Wallace is continuing to make payments.
Mr. Wallace,
Yes,
are you making payments?
yes, I got my check stubs right here. All the payments have been coming out.
Yep, and you're paying extra on the arrearage?
Yes,
All right, so Mr. Wallace, what I'm gonna do is set this over to September 4th at 8:30 in the morning, just to continue to monitor payments. And then we'll see where we stand on that day. And Miss
Are you going to give a
Underwood.
notice, Your Honor?
Miss Underwood, because the AG is not here today, they were in the other court, I'm going to have Miss Adams do the notice of hearing.
Thank you.
All right, so Miss Adams, if we can do the notice of hearing on that. So Mr. Wallace, we'll see you back on September 4 at 8:30 in the morning. Thank you.
thank you.
All right, okay, so. All right,
We have
so
Mr. Spence.
I have a gentleman joining me from the jail. What's your name?
That's Marcus Oglesby, Your Honor.
Okay, Mr. Oglesby, I am going to need you to sit up and speak a little bit louder for me, okay?
Sorry.
Okay, a little bit louder for me. So this is in the matter of the people of the state of Michigan versus Marcus Oglesby. File number 2024-21867FH. Mr. Oglesby, you are representing yourself in this matter. So this is the date and time set for arraignment in this matter. I have received a pretrial statement from Darren Coast, who met with Mr. Oglesby at the Lenawee County Jail. The letter is dated July 10th. It states Mr. Oglesby has been in jail since April 16 of 2024 on a $5,000 bond. Jackson County has a parole detainer on him. He scored a 5 on the Ohio risk assessment system, puts him in the moderate to high risk rating for him not attending court dates or of picking up new charges if out of jail on bond. And Mr. Coast, who is pretrial service coordinator, again recommends that the bond remained at $5,000, as well as he has an assaultive history. So, Mr. Oglesby, this is the date and time set for arraignment in this matter. The felony information charges you that on or about February 8th of 2024 in Tecumseh Township in the county of Lenawee, it is alleged that you committed under count 1 the offense of public officer assaulting or obstructing, did knowingly or willfully assault, batter, wound, obstruct, or endanger investigator Dan Boa, an investigator with MDOC absconder unit who is acting in performance of his or her duties by detaining a parole absconder contrary to MCL 750.4792. The maximum penalty for this offense can be up to 2 years in prison and or a $2,000 fine. Because you were on parole, this offense carries no credit for time served and would be served concurrently. Mr. Coker just popped in, Miss Underwood, so hold on. You're charged under count 2 with public officer assaulting or resisting or obstructing, and that it's alleged you did knowingly or willfully assault, batter, wound, obstruct, or endanger Paul Raymond, who is also an investigator with the Michigan Department of Corrections absconder unit, who is acting in the performance of his or her duties by detaining a parole absconder contrary to MCL 750.4792. This offense carries a maximum penalty of up to 2 years in prison and or a $2,000 fine. This offense can actually stack on count 1 because a consecutive sentence may be imposed for any other conviction arising out of the same transaction. So you understand the maximum penalty under those counts would be 2 years, and then it could stack to be 2 years. But you also have a habitual offender fourth offense notice, which states that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies in or on or about December 7 of 2021. You were convicted of the offense of police officer assaulting, resisting, and obstructing in the 4th Circuit of Jackson County. And that on or about September 28th of 2017, you were convicted of the offense of tampering with electronic monitoring device in violation of MCL 771.3F in the 6th Circuit Court for Oakland County in the state of Michigan. On or about January 12th of 2012, you were convicted of the offense of motor vehicle unlawful driving away in violation of MCL 750.413 in the 6th Circuit Court for the County of Oakland in the state of Michigan. So do you understand, because your underlying offenses are 2-year felonies, your habitual offender fourth offense notice, if you were convicted at trial, could take the maximum penalty up to 15 years. And then you could have 2 15-year felonies that stack on each other. So you would serve your parole time plus 15 years on count 1, plus the maximum penalty of 15 on count 2, and whatever your guidelines are. So Mr. Oglesby, that is your felony information, and I have read it for you and on the record. So at this time, Mr. Oglesby, you have 2 choices. You can plead guilty or not guilty. So how would you like to plead, Mr. Oglesby?
Not guilty.
All right, so Mr. Oglesby, you are currently without counsel. And so I am absolutely obligated and highly recommending that you have counsel, because there's an old saying that you should never represent yourself. So Mr. Oglesby, I am offering you the ability to, you don't want a court-appointed attorney? Is that a no? You got to verbalize no. All right, so Mr. Oglesby, at this point, I'm going to set these matters for jury trial. This should be a 1-day jury trial. So let me, Miss Adams, I am looking for the book. Can you bring me the book? How about we have the book? Now, Mr. Oglesby, you understand counsel would be at no cost to you. Do you understand that?
Yes.
Okay. Mr. Steen, Mr. Bayonetto, here. Has a plea offer been made on this file?
Your Honor, this is my case. The offer would be as charged, no subs. Just so the court is aware, Mr. Oglesby is also accused of a shooting at another MDOC parole officer or probation officer in Lansing. I'm not sure what the status of that is.
Is that the one where the officer was killed?
Not where the officer was killed, no. I don't know that anybody was struck at that incident.
So he's got those charges in another county?
They should be coming. I don't know if they've been filed yet, but when I spoke to the investigators last, Ingham County is in the process of getting that ready for charging. But at this point, the offer is as charged, no subs on the two RNOs.
Okay, so let's talk about that, Mr. Oglesby. So because you're self-represented, I always want to make sure that people very clearly understand what's happening in the court proceeding, because I understand and respect that you are not an attorney. So, Mr. Oglesby, I went through your felony information. You've entered a plea of not guilty at this point, but there has been a plea offer made. So I want to explain that to you. You are charged with two-year felonies, right? Do you understand that? Because you have habitual offenders, if you were convicted at trial, that would be a 15-year felony and they could stack. Do you understand that? You got to respond. I got to hear the words.
Yes.
Okay, so the plea offer being made to you today is that you would plead guilty to count 1 and count 2, which are 2-year felonies. So, your sentence could not be more than 2 years and I would not stack them. Do you understand that? So you would serve a sentence somewhere between 0 and 24 months. It would stack on your parole because I have no authority to not do that. Because you're on parole, you would serve any time on parole, so you would not get credit for time served. So, if we do a trial, as long as you sit, that'll go towards your parole violation. So if you accept the plea offer, you could plead today, be sentenced in September, and you would be looking at a sentence of anywhere from 0 to 24 months. It would stack on your parole, but it would not stack on whatever these new pending charges are. Do you have any questions about that?
What you mean by is stack on my parole?
Okay, so you're on parole right now.
Yeah, I ain't got 12-month parole, so why would it stack on my parole?
Okay, but do you understand that when you commit a crime when you're on parole, I can't give you credit for time served?
Yeah, I know it's that time. I know that. But
Yeah, so
what would stack on my parole?
Okay, so say you plead to this, okay? And say I give you, 12 to 24 months with MDOC. You would do your parole violation first and then serve this. So if your time's up on your parole violation, I don't know what that is, then you'll start serving this. But then your new case, I don't have anything to do with that because that's in Ingham County. So, this wouldn't stack.
I don't have a new case. Everything in Lansing got dismissed.
Well, there's a new case pending for allegedly shooting at a correction officer or somebody.
I already got my paperwork saying everything got dropped, man, because I never signed up.
Okay, so, but I'm just saying my case has nothing to do with that, whether it was dismissed or not. So do you understand the plea offer then?
Yeah.
Would you like to take the plea offer?
All right.
Say that again.
Yes.
You would like to accept this plea offer?
Yes.
Okay. All right. Do you have any questions? Because I really want to make sure you fully understand what you're entering into. Do you have any questions?
No.
All right. So, Mr. Oglesby, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Now, Mr. Oglesby, I read to you the felony information, so you fully understand all the charges against you, correct? I'm sorry, we're not picking up audio. Can you say that again? Okay, and the plea offer that was made by the prosecutor is that you would plead guilty to count 1 and count 2, and your habitual offender third offense notice would be dismissed. Do you understand that plea offer?
Yes.
Okay, and the maximum penalty will remain up to 2 years in prison, and I won't stack those two on each other, and your habitual offender will be dismissed. Do you understand that?
Yes.
I gotta step out here.
Okay, so Mr. Bayonetto, is that a correct recitation of the plea?
It is, Your Honor. Mr. Sneed is going to.
Okay. All right, so Mr. Oglesby, again, Would you like an attorney to represent you?
Okay, I guess.
Okay, all right. So, okay, so I can appoint you an attorney today, or I can appoint you an attorney for sentencing. What would you like to do?
I'll just take one right now. If that's fine with you.
Miss Underwood, I know that I take advantage of you all the time, but Miss Underwood, would you be willing, or Mr. Malaro perhaps, be willing to talk to him and make sure he fully understands the plea offer?
Let me talk to Mr. Oglesby for a minute, Your Honor.
All right, so Miss Underwood, the plea offer is plea to count 1 and count 2.
I've listened to everything.
Okay, and then I will not stack those. Okay, but he is on parole and he seems to understand that. So Mr. Oglesby, I'm gonna open up a breakout room, and Miss Underwood, because I want to make sure to protect your rights, that's my job, is going to go through the plea offer with you and talk to you about that. So you're in jail room 3. Okay, I'm opening that room. Can you click on join that breakout room? Are you here for Eric Miller?
That's Matt's case.
Huh?
I got Matt Murphy's.
Yeah, she's from MDOC. She's down there, right?
Yes.
Yeah. So, okay. So we're gonna take like a 2-minute break while Miss Underwood speaks to Mr. Oglesby. I don't have anybody in my jail windows. So let me just.
I gotta go talk to him. Get a plea offer. Well, you gotta show for court. Yes, that. So, what's going on with this kid? He says kidney. He said one of his kids needs a kidney. Troy said one of his kids needs a kidney. Is that true?
No. Well, I haven't had Troy said.
He said that one of his kids needs a kidney. Yeah, he's pregnant.
I know.
What's going on? What's going on?
I told him that office had to be very low. They did tell him, yeah, and the people, but I haven't. Busy day here today.
Yeah. Busy good. I like that every day.
What's that?
It's busy every day.
Is it? Well, we don't have to come very often.
That's good. Sorry.
Steps in today. All rise.
You can sit down. All right. Now. All right, Ms. Underwood, I'm gonna close that breakout room, and once again, I always appreciate that you go above and beyond to help us out. All right, so it should close. There we go. So Mr. Oglesby, we're back on the record. Have you had a chance to speak with Ms. Underwood?
Yes. Yes.
Are you satisfied with Ms. Underwood as your appointed counsel and the advice that she's given you? All right, and Ms. Underwood, again, I appreciate you speaking with Mr. Oglesby. Ms. Underwood, how does Mr. Oglesby wish to proceed today?
I believe Mr. Oglesby wishes to take the plea at this point, Your Honor.
Okay, so Mr. Oglesby, raise your right hand for me. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, so you can put your hand down. So Mr. Oglesby, you understand the maximum penalties for these offenses could be up to 2 years in prison and that they will run together concurrent, but you understand it's consecutive to your parole, correct?
Yes.
Okay, now, neither the prosecutor, the defendant, nor anyone on his behalf has discussed a possible sentence with the court. Is that correct, Ms. Underwood?
That's correct, Your Honor.
Mr. Sneed?
Yes, Your Honor.
And is that correct, Mr. Oglesby? I've explained what the penalty can be, but I haven't promised you anything. Is that correct?
Yes.
Okay, now, sir, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
All right, so sir, on count one and count two, how do you wish to plead to the charge that on February 8th of 2024 in Tecumseh Township in the county of Lenawee, that under count one, you committed the offense police officer assaulting or obstructing? Guilty or not guilty?
Guilty.
And on count two, police officer assaulting or obstructing? Guilty or not guilty?
Guilty.
All right, has anyone made any threats or promises to you other than the plea bargain that was placed on the record to induce you to plead guilty to these charges?
No, ma'am.
Do you understand if I accept these pleas, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Mr. Sneed?
No, Your Honor.
Now, Mr. Oglesby, neither I or your attorney has promised you any particular sentence or estimated what your sentence would be, other than it would be within that 0 to 24 months. Is that correct?
Yes, ma'am.
All right. Is it your own choice to plead guilty today?
Yes, ma'am.
And you feel that you've had enough time to think about this and understand the plea? Is that correct?
Yes, ma'am.
Okay, good. All right, so Mr. Oglesby, on February 8th of 2024, were you in Tecumseh Township in the county of Lenawee?
Yes, ma'am.
Now, at that time, some people from DFAT or Detroit or the MDOC absconders unit, you came in contact with a Dan Boa and a Paul Raymond. Is that correct?
Yes, ma'am.
And they were trying to take you in custody on a parole violation. Is that correct?
Yes, ma'am.
So you're charged with assaulting, battering, wounding, obstructing, or endangering these officers. So at the time they tried to take you in custody, did you run away from them? Did you push them away? Did you struggle with handcuffs? Can you tell me what you did?
I didn't get down on the ground as fast as they wanted me to.
Okay, so they gave you instructions to get down on the ground and you did not do that?
I believe the allegation is that Mr. Oglesby did not show his hands, did not comply with that order, Your Honor.
Would that be correct, Mr. Oglesby?
Yes.
All right, Mr. Sneed, are you satisfied?
Yes, thank you.
All right, I accept that, has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has, Your Honor.
And Mr. Sneed?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. So it's a second, let's see, 1, 2, 3, 4, 5, 6. So Miss Underwood, I am going to set this matter for sentencing on September 6th at 8:15 in the morning.
September 6th.
September 6th at 8:15 in the morning. So Mr. Oglesby, somebody from our corrections department will come over to the jail and they're going to meet with you, and they'll have you fill out a packet, and then they'll ask you questions. Be truthful about your background and the events that occurred. They'll prepare a pre-sentence report. We will provide a copy of that to Miss Underwood, and Miss Underwood will review that with you before sentencing. And then do you want to appear in person or via Zoom for sentencing?
That's your choice.
Okay, so we'll set that for Zoom sentencing. And okay, so very good. All right, we'll see you back on that day, Mr. Oglesby. Thank you.
Okay, you're welcome.
Thank you. Miss Underwood, again, thank you very much. My notes. And Miss Underwood, would you keep that file? I don't know who. That'll stay your file, right, Miss Underwood?
I'm sorry?
You will keep that file? I mean, I don't typically,
Yeah,
I just.
Your Honor,
okay.
I was originally on that file.
Okay. All right, count 1 and 2, dismiss subs. All right. I'm just trying to put my notes in the file and okay, so very good. Thank you for that. All right, I have empty jail windows.
No, I'm ready on here, familiar.
Okay.
You said Mr. Owuta Coker popped in here.
He popped in and he's gone now. He probably had another court he had to be at. So we took care of that one. Sprague's not coming over. We took care of Rogers. We just need.
What about Spence, Your Honor?
Well, Mr. Spence, hold on 1 second. 2382. Okay, hold on. I just need Mr. McKenzie. This is Judge Anslow. The last one I have is Casey McKenzie.
All right, I don't know, yeah, we had to kick him out. I don't know if you were told that.
No.
No, yeah, he was looking up porn on the computer while he was waiting for you, so.
Well, we all get bored, I guess. All right,
Yeah.
thank you.
Yep.
Bye. How do you even have the access to do that?
Yeah, I was gonna say, don't look up porn.
Yeah, he was looking up porn while he was waiting for us, so.
Wow.
All right, so I can take Barton Blake. No. Okay, so this is in the matter of the people of the state of Michigan versus Blake Anthony William Barton, file number 23-21272 FH. I have Isaac Sneed appearing on behalf of the people, and I have Matt Murphy appearing on behalf of Mr. Blake. So this is the date and time set. What is this?
Your Honor, there's another pre-trial awaiting, the prosecutor's appeal, Your Honor's decision.
Oh.
Last update from the Court of Appeals, they received my answer. They notified us that they will schedule oral arguments, but we haven't received a scheduled date yet for the oral arguments. Now, Mr. Barton, I don't know if, I don't think Mr. Coast is here. I believe that Your Honor had dropped him off the scram unit. I would ask the court if we could excuse his non-presence today. I don't know why he's not here, but he's appeared. This case has been going on for quite a while. And I don't think I would waive his appearance. I was going to ask for it to be adjournment. Obviously, I don't think that, he has no reason to flee from this case.
Well, in this case, it's post-appeal, so I don't know that he needs to be here. So, Mr. Sneed, do you want me to set this out for another pretrial like in September to see if we hear anything?
Yes, please.
All right, so I will set this for pretrial September 4. at 8:30 in the morning.
Yes, Your Honor.
And Miss Adams, we might need to do the notice on this because I don't know if we have to send something to the Court of Appeals. I don't know. So pretrial conference, September 4 at 8:30 in the morning.
Yes, Your Honor.
And I'll have, and Miss Adams is gonna be kind enough to do the notice.
Thank you, Your Honor.
So, I have one jail room open, so as soon as Mr. McKenzie gets here, we'll take care of him. So, but we'll skip over to, let's see here. Skip over to Miss Miller. So this is in the matter of the people of the state of Michigan versus Erica and Soon Miller, file number 24-21693FH. So I have Isaac Sneed appearing on behalf of the people, and I have Matthew Murphy appearing on behalf of Miss Miller. This is the date and time set for pretrial. We are scheduled for trial on June, well, I guess the trial passed.
Yeah, Your Honor, in regards to this matter, we had some issues. The prosecutor's office failed for whatever reason to writ Ms. Miller here multiple times in the past. There's a plea worked out. She wants to enter the plea today from my understanding. There's confusion because the information I have, she was originally charged with possession of methamphetamine, which caused issues.
All right, I'm gonna pause everybody real quick. So can you guys have a seat? Okay. All right, so this is in the matter of the people of the state of Michigan versus Casey Michael McKenzie, file number 23-21324FH, 24-21789FH. I have Mr. McKenzie joining us from the Lenawee County Jail. This is the date and time scheduled for a pretrial on violation of probation files. So the two files I have on my docket today are merely the violation of probation files. So Mr. Malaro, I guess I would ask, is there an update for the file in district court?
Judge, I thought we had a pretrial schedule for that as well.
Oh, is it both? Oh, maybe that 24 file. Oh, well, there's an order for fingerprints. So I have 23, which is a probation violation. Did we get that one out? Probation violation. I guess I do have the new felony file. So it is pretrial file number 24-21789FH. So, Mr. Murphy or Mr. Malaro, how would you like to proceed?
Judge, on the pending felony case, we'd ask the matter be set for adjourned out for another pretrial. As for the violation of probation, I'd ask that be set for hearing.
Okay, so how far out would you like to pretrial on the new file?
30 days, right, work.
Meetings, how about September 4 at 8:30 in the morning?
Yeah, we just received, for the record, Your Honor, we just received the transcript. I did send that over to Mr. McKenzie. I'll be over to talk to him about that in the near future. So that's the basis for the request.
Okay.
On the pending felony, on the probation violation, we're probably ready at any time of the courts.
Okay.
As long as I'm here.
So I'll continue as not guilty plea on file number 24-21789FH. I'll set that for pretrial September 4 at 8:30. And then on the probation violation file, which is unrelated to the new file, I will set this. So witnesses, we need someone from that place. So a couple weeks.
Your Honor, yeah, I have the RAF termination report that I can admit into evidence.
We get, well, the best evidence rule, you got to have a witness. You can't just admit it.
Okay.
So you have to have the person that drafted it.
You try.
Well, you could try, but it wouldn't be admissible. So you need the person to testify.
Can she appear via Zoom?
I don't think he was willing to do that. No. So she's gonna have to come in person. So I'm looking at Mr. Murphy, are you on Banzo? You on Banzo?
I am not.
Oh, it's okay. It only takes about an hour for these. So
You know, first day.
She was here earlier.
You let her go?
No, I don't have that authority.
She was here?
Yes.
I don't know what she looks like. What about before drug court on August 15th? 8 o'clock?
Okay.
All right, so I'm gonna set this over for the violation of probation on 23-213-24FH. I'm gonna set it over for August 15 at 8 a.m. That'll be in person. And that'll give you time to subpoena her back. Anything else, Mr. Malaro?
No, Your Honor, thank you.
All right, Mr. McKenzie, you're all set. Thank you.
Thank you. Thank you.
I just want to know how our jail Zooms have the ability to look up porn. So.
Yeah, Mr.
Yeah,
Morrow's
taking out a
computer
room,
can't
Zoom.
connect to the.
Looking at porn on the Zoom unit, yeah.
I thought they were in all black.
Yeah.
You would think.
All right, so we're back with you. Apologize. All right, so, you said that,
Sorry, I was gonna explain the offer on the record.
yep,
The people that offer, because Ms. Miller was originally charged with possession of methamphetamine, a 10-year felony. At the examination, the lab results were produced that show that it was cocaine, obviously not methamphetamine. So that was causing some issues, but at this time, again, the information I believe the court had, this is why I still have an information that says methamphetamine. I believe the offer is for her to plead as charged with the court's information, which would be possession of cocaine or heroin, 4-year felony, no habituals, no supplements on that. If that's correct, again, it was, because Mr. Granetto said as charged, and I wanted to make sure, well, as charged, what I see is methamphetamine, but it's pleading.
so the felony information I have dated January 23rd of 2024 is fentanyl heroin.
Yeah, that's, so she's gonna plead the possession of heroin, the 4-year felony. With an agreement that she's currently serving time in MDOC on a sentence that'll be concurrent for, current concurrent time. And I'm gonna explain at sentencing, one of the issues in regards to the length of time it's taking this case, and I'll ask myself at sentencing, but again, she wants to plead no contest to possession of heroin.
No contest.
No contest, right?
Right.
Grace felt lack of memory from.
So the felony information, fentanyl heroin. You said cocaine though?
I'm sorry, I just had that in my, I don't know, it was.
Okay.
It's just saying it's 4-year felony.
Okay, okay. So is that a correct recitation of the plea, Mr. Sneed?
Yes, it is.
So she'll plead guilty to count 1,
No contest.
possession, no contest. And the habitual offender 4th offense notice will be dismissed. Okay, anything else?
Nothing further on.
All right, want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, ma'am, can you state your full name for the record?
Erica Ansley Miller.
Okay, thank you. Now, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest to count 1, controlled substance possession of fentanyl heroin less than 25 grams?
Yes, it is, Your Honor.
All right, and you understand the maximum penalty for that offense could be up to 4 years in prison and or a $25,000 fine. Okay, and the habitual offender 4th offense notice will be dismissed. So you're satisfied with Mr. Murphy as your attorney?
Yes, Your Honor.
Okay, and neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Murphy?
Yes, Your Honor.
Is that correct, Mr. Sneed?
Yes, Your Honor.
And Ms. Miller, is that correct as far as you're aware?
Correct.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Ma'am, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you'd been convicted at trial?
I do.
Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yeah.
Do you have any, if you're not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization? Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right, and your response would either be not guilty or no contest. So how do you wish to plead to the charge that on or about July 25th of 2020 in the city of Tecumseh in the county of Lenawee, that you did commit the offense of controlled substance possession less than 25 grams?
No contest.
Okay. Has anyone made any threats or promises to you to induce you to plead no contest to this charge?
No.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
Yes.
Okay. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Sneed
No, Your Honor.
and Mr. Murphy?
Your Honor, I've discussed with Mr. Miller the issue involving the length of time it's taken for the case to come to this point, and I was going to express that at sentencing why I was going to ask for the sentence I was going to ask for. That's the only promise I made, though, Your Honor.
There was no sentencing agreement though, right? No.
No, yeah, well, there's an agreement for it to be concurrent with what she's currently serving, which she's been doing for quite some time now.
Okay. I just want to make sure. Then. Okay. Would you agree with that, ma'am?
Yes,
All right. Is it your own choice to plead no contest?
Yes, ma'am.
All right. So, Mr. Murphy, are you going to place the factual basis on the record?
Yes, Your Honor, and the basis for the no contest is that again, this occurred back in July of 2020.
So lack of memory.
And I'm going to go based upon the preliminary examination. We would stipulate to the following facts and believe that they were established at the preliminary examination and will be further established at trial. That Ms. Miller was indeed in the city of Tecumseh, the county of Lenawee, state of Michigan on July 25th, 2020. At that date and time, she had an encounter with some police officers. A search resulted in her possession of some controlled substances. At first, it was believed to be methamphetamine, but it was later determined to be heroin, I believe. And she was knowingly in possession of that. She knew that to be that. Again, was the issue was she knew what it was, and she was really charged with the wrong substance, Your Honor. So again, I believe that those factual basis will be established, and we believe that would establish.
And she had no legal authority to.
She had no legal authority to possess heroin or fentanyl or any of it.
Okay. Mr. Sneed, any additions or modifications?
No, thank you.
All right, based on the facts placed on the record and from the information contained in the police report from the preliminary exam, the court finds beyond a reasonable doubt that on or about July 25th of 2020 in the city of Tecumseh, in the county of Lenawee, that the defendant did commit the offense of controlled substance possession of fentanyl or heroin less than 25 grams. And therefore the court accepts the no contest plea. Has the court complied with MCR 6.302 B, C, and D? Mr. Murphy?
Yes, Your Honor.
Mr. Sneed?
Yes, Your Honor.
All right, as I said, accept the plea. It's been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the concurrency of the sentence. I'm going to schedule this matter for sentencing for September 6th at 8:15 in the morning. So, Ms. Miller, you do have the right to appear in person, or you can appear via Zoom. It's really up to you. What would you like?
In person.
Okay.
Do you like to be in person, Your Honor?
Okay, so we'll schedule that in person. Now, Ms. Miller, someone from MDOC is going to get a hold of you. Obviously, it's a no contest plea, so you don't have to make any statements regarding the incident itself, but be truthful with them about your background. And then they'll prepare a pre-sentence report. I'll provide a copy to Mr. Murphy. They really make a valiant effort to meet with people over Zoom with MDOC, but MDOC has a lot of people trying to get in and meet with people. So sometimes they can't. If he's not able to meet with you in advance, he'll have time that morning to do so, okay? All right.
Your Honor, would, if the PSI is prepared earlier, would it be possible to schedule it sooner?
So we're down probation or a correction officer, so it probably won't be, but if you get it, call us and we'll do our best to rid of it.
Yeah, I know also there'd be an issue with having the writ prepared in time, but I was
I
just
know.
about to make sure because.
We'll try, so, but you'll have to make sure to call Ms. Adams and see if we can.
Yes, Your Honor.
Okay, because I won't remember. All right, so you're all set. Thank you, ma'am.
Thank you, Your Honor.
All right, so Miss Underwood is here.
Spence, Your Honor.
Mr. Spence was here this morning. The probation office, we just adjourned it out to November. He's in a treatment. I didn't appoint an attorney on it.
Okay, thank you.
And
Then I
then
think I'm
Mr.
done.
You're done?
Thank you, Your Honor.
Okay, so